hello, everyone. Welcome. I'm so glad so many of you could join us here today. My name is Leah, and I'm the Director of Programs here at Women's Shelters Canada. I'm joining you today from the traditional unceded territories of the Algonquin Anishinaabe people in the city colonially known as Ottawa. And I'm going to be hosting our session today. And so, with all of that said, I will give you a little bit of a sense of what today's going to look like. In just a moment, I will pass things over to Myra Martin, the Executive Director of Action Ontarienne contre la violence faite aux femmes, an Ontario Association for Francophone GBV organizations. And she's going to give us a bit more context about what brings us here today and sort of introduce the webinar in that way. We'll then have two presentations. So we will hear first from Anchal Bhatia, staff lawyer at South Asian Legal Clinic of Ontario. And then we will hear a second presentation from Mattoo, the CEO of the YWCA Toronto. They're going to cover slightly different angles or pieces of our topic, and then we'll do a joint Q&A at the end for all of your questions together. So that's what we're going to do. And we are recording. We'll share the recording afterwards. We'll share copies of the information. So you can keep that in mind as we go through. And without further ado, I will pass it over to Myra.
Hello, and everyone, in the name of all the organizations that you see or that you will see on your screens in a few moments, it is my pleasure to welcome you to this webinar about the so-called red flags laws. Last fall, we all received a letter from the Office of the Chief Coroner in Ontario regarding recommendation number 11 of the Domestic Violence Death Review Committee's report. So this recommendation encourages us to inform our membership, our team members, professionals in the gender-based violence sector about those laws, those red flag laws. So instead of working in silo, each of us on our sides, we've decided to collaborate, and the result is today's webinar. In a few weeks, we will share with everyone interested a written resource. The document will be available both in English and in French. So we are all aware of the fact that the law and the mechanisms that are within the existing laws are there to reduce risks of violence, but we all know that they're not perfect and that they can be difficult to understand for survivors and those who support them. Despite the challenges and the imperfections, they are still useful tools for certain survivors, and it is important for us all to be aware of their existence. Before inviting today's main speakers, I would like to take the time to thank all the partner organizations working around this initiative, especially Women's Shelter Canada, who have coordinated today's webinar. I also want to thank both speakers. Thank you for being here, for sharing your expertise. Thank you for sharing information about the laws. Finally, thank you to everyone present here today. I see that there are many of us, so that's a true pleasure to see. I hope this webinar will help you understand the legal dispositions that we have access to. Thank you.
Merci beaucoup, Myra. Excellent. And so I will, without further ado, pass it over to our first presenter, Anchal Bhatia, a staff lawyer with the South Asian Legal Clinic of Ontario, to start off our presentations today. Over to you.
Thank you. Okay, so good afternoon, everyone. My name's Anchal Bhatia, as mentioned, and I'm a staff lawyer at the South Asian Legal Clinic of Ontario, which is a legal clinic in Ontario that provides legal advice and representation to low-income South Asian identifying folk in areas like tenant rights, welfare, immigration, employment, human rights, and we support survivors of gender-based violence. Today, I'll be walking us through the technicalities of the red flag law, starting at what the provision is under the criminal code, the process on how to apply, what happens after, what a judge can decide, what role the police would have, and then some limitations and exemptions. The right to apply for an emergency provision order is contained in Section 110.1 of the Criminal Code. It states that any person can apply to a provincial court judge for an order to prohibit another person from possessing firearms, ammunition, certain weapons, or explosives. The main requirement is that the person applying for that order must believe on reasonable grounds that it is not desirable for public or personal safety reasons for that person to possess the weapon. The judge will grant the order if they believe that there is a safety risk and immediate action is needed. They can decide to prohibit the person from possessing and order that the items be seized and removed. They can prohibit the person from possessing firearms, crossbows, prohibited or restricted with weapons and devices, ammunition, and certain explosives. The order is temporary for up to 30 days. However, a judge or police, peace officer, firearms officer, or chief firearms officer can request a longer prohibition order under Section 111 of the Criminal Code. That duration would be for up to 5 years. Alongside Section 110.1, the Criminal Code in Section 117.0101 establishes that any person can apply for an order that sets rules on how firearms, etc., should be stored or accessed by the person subject to that order. For example, that order could indicate that they must be stored in a third-party location and can limit when those weapons can be accessed. The law requires judges to lay out the least intrusive rules necessary to manage that risk, but if warranted, can order that the firearms be removed temporarily. As mentioned, the Act uses the language of any person, which means that there is no restriction on who can make the application. So it could be the survivor of intimate partner violence, it could be a family member, a friend, healthcare, or social service provider, neighbors, coworkers. Really, it could be almost anyone. The person wanting to apply must do so through their local, provincial, or territorial court. There's no requirement to have a lawyer to do this, but potentially seeking legal advice may be helpful. This is an ex parte application, which means that when you apply, the person who you're applying for the order won't be notified before the hearing takes place, and they won't be present when the application is assessed by a judge. The applicant can also request further protections for their own privacy, so they could have a private hearing, they could have documents sealed or certain information redacted. In Ontario specifically, there's no specific or standardized form that you would need to fill out. You would just go to the local courthouse where in Ontario Court of Justice sits in criminal matters, and you would tell a staff member there that you want to apply under Section 110.1 or 117.0101. The court staff, a justice of peace, or duty counsel would help you complete something to fill out that request. So it could be an internal form or an affidavit or some other written material to confirm who the order would be against, what firearms or weapons they have, and why you believe there is a safety risk. If you wish, you could include evidence on, again, to support your claims, but that will also, you'll have an opportunity to present that evidence at a hearing as well. So the next step is a hearing would be scheduled. There's no rigid or fixed timelines, but because these are defined as emergency applications, they are prioritized and can be heard on the same day or within a matter of days. Attendance by the person who applied for the order is mandatory, and you can attend either virtually or in person. If you don't attend, or if the applicant does not attend, then either the matter will be delayed or the order might be refused, especially if the written materials is not strong enough on their own. As mentioned, you can request privacy protections like removing certain information from court documents or redacting it, and this can be done at the hearing as well. The reason it is important for the applicant to attend is so that they can answer any of the judge's questions under oath and clarify details in the written statement. It would allow another opportunity to present evidence and also allow for the judge to assess the credibility of that evidence. So some evidence that might be helpful would be personal notes, police call records, video or oral evidence of threats. So when you make an application for a prohibition order under Section 110.1, there are two potential outcomes. One, the judge could dismiss the application if they felt or they weren't satisfied that there was a reasonable risk, or they could grant. If they grant, then that order would be for up to 30 days. So again, it would be an order prohibiting someone from possessing any or all of the following weapons. And then once, if the order is granted, that would be sent to the person that was subject to the order. So in regards to Section 117.01, similarly, there are two outcomes. So once again, the judge could dismiss if they weren't satisfied, or they could impose any terms and condition on the person's possession, use, carrying, transport, or storage of the following weapons. Some potential orders that could be made are that they would be required to store the weapons at a different and secure location. For example, a trusted third party, requiring the firearms to be unloaded, locked, and stored in a way that a specific person cannot access, not allowing them to use the firearms. And then the severest thing that they could do is that they could order for the firearms to be removed. The judge in these cases do have to consider, again, the least intrusive way to apply the rules first. In regards to enforcement, once an order is made, the police would receive a copy of that order, and it is their responsibility to enforce when they reasonably believe a person is ignoring the order, which can result in criminal charges. So they're allowed to attend a home, vehicle to search and seize the listed items, and then the police could store those items as either evidence or for safekeeping. So the act allows the provincial court judge on oath to create a warrant based on information received on oath to create a warrant for search and seizure if they believe that the order hasn't been followed, or the police can do so without a warrant if they feel that there is possible danger or safety to a person and would not be practical to obtain a warrant for search and seizure. In either situation, they do have to immediately make a report to the justice once they've completed the search and seizure. These emergency orders are temporary and for a short duration, unlike the expansive nature of the emergency order in general, which the long-term prohibition requires a separate hearing, and that process can only be started by limited individuals, so either the police or judges. And judges can only prohibit what is already listed in the code. On access, they have to, again, start with the least intrusive means first, and there is a way for the subject to apply to cancel that emergency order. In addition to the appeal, the subject of an order can also ask for it to be lifted based on an exception that they need firearms for sustenance, hunting, or an employment exception. And then finally, Section 117.07 of the Criminal Code does exempt public officers from firearm offenses when they deal with firearms in the course of their duties. However, that exemption is not a blanket exception that gets them around prohibition orders. But as mentioned, they could still appeal or ask for it to be lifted if it's related to their employment. That's it for me. Thank you.
Amazing. Thank you so much. That was a very informative overview of the law and the framework itself. So thank you for that foundation. So just a reminder to put any questions that are coming to mind as we go through into the chat, and we will get to those at the end of our time together. And right now, I will pass it over to Deepa, the CEO of the YWCA Toronto, to dig in a little bit further to some of the implications of what Anchal has just shared with us. So over to you, Deepa.
Thank you, Lee. Can anyone confirm that they can see my deck?
Yep,
Because
that
I'm not.
looks great.
Okay, awesome. So my point of entry in this is going to take a slight step back. But before I go into that, I just wanted to let you know, for folks who don't know about YWCA Toronto, we are an association of by, for, and about women and gender diverse people, and our programs include um, uh, housing, employment, training, community supports for girls and families as well, and we engage in systemic advocacy to advance gender equality and racial justice. So just to get us started, let's look at, just to get us started, let's look at what is the intent of the law and why this law and what philosophy or ethos this law came into existence was. The primary philosophy behind Bill C-21 is proactive intervention rather than waiting for a crime to happen or a tragedy to occur. The law seeks to identify red flag and remove the means of harm before a crisis escalates. So the intent can be broken down into three pillars as given here. You can think about public safety, which is reducing the prevalence of firearms and volatile situations such as domestic disputes or neighborhood threats. It can also be seen as suicide prevention to provide legal mechanism to temporarily remove firearms from individuals who are experiencing that kind of trauma. And lastly, it can be seen as empowerment, which is giving communities some tools or healthcare professionals some tools and family members some space to actually do take steps into a direct legal path and voice their concerns and seek immediate action. I just wanted to share with you some risk trends, and I also want to let you know that I am member on Ontario's Domestic Violence Death Review Committee. So when some of these recommendations have been made for all of us to be better aware, I've been part of those conversations. So looking at the rising risk trends and why this kind of education and information and laws are really needed is relevant for all of us. So since 2013 to 2020, there has been 91% increase in firearm homicides. The presence of firearm in a home where domestic violence exists increases the risk of death and femicide by 12 times as compared to a non-firearm incident. And 75% of firearm deaths between 2000 and 2022, the vast majority were related to deaths in Canada, were actually suicides and not homicides. So, temporary pause, the law creates a cooling off period. It removes the firearm from the situation during acute mental health crisis and also where there is a possibility of a self-harm at its peak. It also creates a room for the medical support because it empowers healthcare professionals to intervene legally when they identify a patient who poses danger to themselves. Red flag laws, as Anchal has kind of shared with us, allows professionals to bypass the client. So the person who we are dealing with to apply for a court order directly. The shifts from the collaborator to the petitioner can shatter the therapeutic bond at times, and therefore it's important for us to think about as we create processes, how do we make sure that we can deal with the feeling of betrayal that people might feel with service provision. And in case of minors, I think we should always be centering their needs and think about the duty to report, which many of us have, and how, when that is invoked, we respond to those. So if you think about the tool that this law gives us, the risk and the benefits and the challenges, first looking at the benefits, there is a possibility that there will be lethality reduction and there will be an immediate removal of the most lethal tool from the household. There is a possibility for advocates to do a third-party applications and basically potentially diverting abusers' anger from the survivor or a person who's experiencing the violence. There is a legal provision to keep survivors' name out of public record. The challenges, which could be some of the systemic risks that many of us are very well aware of, there is a retaliation window. So service of the order can trigger a violent escalation. And we know that, unfortunately, with the understanding of how the risk works in the situation of lethality and violence, that people, when they know that there is a report happening or when they know that there is a justice system or a legal system being involved or invoked, the escalation and retaliation window is at its peak in most cases. So there is a system mistrust with people's experiences and coming from various intersectional backgrounds. So requiring to involve police can be a barrier for folks from marginalized communities and racialized communities and historical colonial structures. And there could also be some false security. So removing the gun doesn't necessarily mean that abusers' intent or their violence is going to automatically get removed or end. And there can at times be some fear of false security created by this removal of the weapon. The trust gap and the intersectional realities that I started talking about in the last slide are quite present in many communities that we work with. We are talking about racialized survivors with a history of over-policing, making the call for help or seeking support very difficult with the system because we know that system itself can be inflicting violence. The system betrayal, which is the documented failures of the justice system to protect Indigenous and Black survivors, means that there is a deep-seated mistrust in our communities, as well as the criminalization of survivors that we see in many of our experiences. And then lastly, the immigration status. We see that a lot of communities coming from non-status and immigrant or precarious status communities, they are in this constant threat of surveillance and possibility of reporting to the CBSA that they might be living under the fear. And there is trapping and a silencing that can happen for those communities. Some other challenges that I think we all probably are aware of, but it's really good to center it in this conversation, is the urban and rural divide. So rural survivors face massive response time and high visibility in small towns, and urban survivors face dense, often adversarial police presence in marginalized zones. We have the reality of the LGBTQS2 communities to be centered, because the identity-based discrimination and fear of institutional bias is also very real for those communities, and survivors risk losing their only supportive community by engaging in a traditional legal system. And lastly, the disability and access piece, which we also know that the procedural hurdles for people from disabled community or equity-seeking communities sometimes also face a lot of discrimination as well as marginalization when they're trying to access supports. So as agencies who would act as conduit in many of these situations, what are things that we should be thinking through for all those pieces that Anchal shared with us earlier? I think one of the pieces that I would invite all of us to think through is in our intake and screening processes, embedding some specific trauma-informed questions about firearms, access and ammunition, and not making it about only certain cases, but having it included in all intake and assessment. Privacy protocols, so thinking about developing some clear MOUs regarding when an agency will apply for EPO and how a survivor's anonymity will be maintained throughout the process. And then legal partnerships, which means that establish some direct referral pathways to legal clinics who could support survivors from receiving independent legal advice when a situation like this is evolving. Suggested actionable step from my side is, as an offer to all of you, is update your risk assessment form to include firearm flag that triggers immediate legal consultation and housing-focused safety plan. Again, from the point of entry of safety planning, thinking about some other important pieces with this legislation and processes that we all should be thinking through and developing. There is a critical risk window, the 24 to 48 hours after an abuser is served and firearms are seized. This is the highest point of lethal retaliation, possibly. So it's really important that the survivor should be at a secured location. It could be a shelter, a hotel, service, or any other safe space which you can work with the survivor collaboratively, coordinate with the police for real-time notification of the seizure, as well as digital sweep, making sure that survivors' phone or any other digital devices are protected, and it could be password change or switching off the GPS tracking or giving a completely new gadget where needed. The advocacy piece that I think which is really important for all of us to understand the handoff and the boundaries is that GBV advocates are really, really relevant. Like many of you in this space, I see do this work. So your job will be to support with safety planning and navigating the process. Most definitely, people who are not trained to do the legal work should not be giving any legal advice. The court is required to review the evidence and do ex parte orders and emergency order. They are supposed to do the determination of the legal risk. And police, of course, can do a lot of responsible enforcement, but they are the ones who are responsible for serving the order and actually seizing the weapon. So we are the ones, I know that I am a lawyer as well, but I see myself as the conduit of the system. As an advocate, we are the ones who are bridging the gap and not own the enforcement. Some of the core principles that a lot of organizations, such as the one I come from, will have to think through and make sure that we are making sure that we are offering our services in the most trauma-informed way. We have to think about the survivor autonomy. The survivor is the expert of their safety, and how they want to engage with the legal tool and when they want to engage with the legal tool is definitely something we should work with, continue to work with. And I know that many of us are already centering our services that way. But this law, as much as it empowers us to take steps, it shouldn't really take us back into trying to save people rather than working with people collaboratively. Being trauma informed, which is system involvement, is a trigger. Minimizing re-traumatization at every step is our role. We have to think about intersectional justice and acknowledge and mitigate the system level risk for marginalized communities and survivors. And we should think about collaborative safety. Legal tools are extension of safety planning, not replacement for it. And we shouldn't necessarily think that way because the escalation of violence and lethality are all real experiences that we are trying to mitigate. Think through your support. So housing stability, I think we can all talk about it till cows come home, that emergency relocation is obviously something that is needed, but the options are very limited. But it is most definitely really recommended that emergency relocation, if the respondent knows survivors' whereabouts, should be done. There should be some counseling supports that should be offered as soon as the system involvement begins. And there should be independent legal advice offered to survivors to understand the long-term impacts of EPOs, as well as there should be thinking through of economic support for covering costs associated with the moving and hiding. With that, I come to an end to my offering here, and I'm happy to answer any questions along with Anchal and others.
Amazing. Thank you. That's great. So those were both very informative presentations. And so we will sort of move into a question period here with both speakers. And so just a reminder, we do have a few questions already, so I'll get into those in just a second. But just a reminder to everyone, if you do have questions, please feel free to put those into the Q&A box so that we can get to all of your questions. I'm just going to make sure we have both of our presenters on the screen here for questions. All right. So, one question that has come in is sort of thinking about this in a scenario where someone isn't pressing charges versus when there are charges in play. So, this person saying, from their understanding, this law exists so that survivors who don't press charges can access the condition that the aggressor doesn't have access to firearms. Whereas, sort of when there are charges, often there is a condition of no possession in a lot of cases. So, just wondering about that kind of those different scenarios where there's charges or not, and how that might affect this kind of thing.
Yeah, I think that's a good point that maybe that is part of the reason where these laws came from. Technically, even prior to these laws, a prohibition order could be placed against someone to not have access to weapons, even if there were no charges, though arguably if the survivor didn't at least report it to the police, then I think that might have been a harder avenue to pursue because that was limited to the police and courts to kind of launch that. So I think in this context, yeah, this has broadened it up that individuals, survivors, especially if they haven't wanted to or they don't want to press charges, they could still at least kind of remove the weapons from themselves. Deepa, did you want to add anything?
No, you covered it well.
Awesome. Do you have a sense of how use of these laws will be tracked so that we have a sense of how they're used, what unintended consequences might be coming out of them, that kind of thing?
So I can see that there are people, I think, from public safety here who probably are better suited to answer this question. But most of the laws are attached with an evaluation framework and a duration by after which the law is reviewed. I don't have it handy in my hands. My past experiences have told me that a lot of these laws have not been tracked appropriately. Although there will be some stats available, but all of this will be only a learning for us in 4 to 5 years from now. So it's too soon, but and I'm not saying that it cannot change, but my past experience tells me that laws are not tracked really well and not reviewed very well in terms of their usage.
I would agree with that. Yeah. Data collection is very poor. And there was at least, I believe I've seen one report where there haven't been a lot of uses of this law so far. So.
Thank you. And for sure, if there are folks in the session today who have more that they could share on tracking that might be happening, do feel free to put that into the chat or send it my way, and we can share that as well. And on that note, I'll say someone had asked in the chat earlier on whether anyone knows of posters or resources that they could kind of put up in their agency to share some of this information. And in response to that, one of the participants did share the link to the public safety website, which does have some resources on it. So I've put that in the chat, but Deepa or Anchal, if either of you know of other resources that might be available for folks, you're welcome to share that. Or again, if other people in the chat want to share things they know about too. Um, and there's a couple questions sort of touching on what happens after the 30 days. So, what's the process like? Well, yes, essentially, what happens after the 30 days? Is there a process where someone could kind of apply to get their firearms back? What does that look like? How are firearms licenses dealt with? So just some questions all touching on some of those pieces.
So my understanding is that there's no specific process to apply, but it is just supposed to be returned. Like if the police have it, then they're just supposed to give it back after 30 days.
It also, depending on, so we are talking about EOPs a lot, but not every weapon is seized as a EOP. So it's a standard process that basically, as Anchal is saying, right? So standard public safety seizure release is the process that will be followed. So if it is not EOP, the return of property basically has to happen, and people will apply for that and they will get it back. Of course, at that point, there will be due diligence done, and they will look into the license and all of those other things. But return of the property actually can be applied for as soon as the order expires.
And is there sort of a follow-up or related to that? Is there a process in terms of like mental health screening or anything that needs to happen before someone gets firearms or a weapon back? Or, yeah.
I mean, should it happen? Absolutely. If there's no formal hearing, that has not happened, and there's a big role for the judge here, then something that is worth noting is that the weapon could be staying longer than 30 days also. But I am not 100% sure that in every case where there is return of property happening, there is a screening of that level that is happening, where they're looking at people's current mental health and state. I'm sure in some situations it does happen, but I'm not 100% sure if it happens as a standard process at this point. Um, and yeah, that's all I can say.
Great. And I'm just going to remind folks in the audience as we're going through, if you do have questions, please do put those in the Q&A, because there are some coming in through the chat, and I'm doing my best to watch them all, but they do get lost in the chat. So please use the Q&A. So some questions around kind of the enforcement. So once the order is issued, is the person expected to comply themselves? Do police seize the weapon? What happens if someone purchases new weapons while they're under one of these orders? So just, yeah, some enforcement questions there.
So it's not my understanding that the police will come to seize it. It's mostly the person has to comply. The police can get involved if they reasonably believe that the person has not complied with the order, or someone has gone to the judge to testify that the person hasn't reasonably complied, and then therefore the judge issues a warrant for that, then the police would act on the warrant. But otherwise, the police are not just going to kind of proactively go and seize the weapons. And then, Deepa, I don't know if you're better informed about what would happen if they tried to purchase new weapons.
I mean, my understanding, which is an ideal situation, is that your license is is at that point suspended, and you should not be able to buy a new weapon. Now, if you're buying a weapon by some other means, that's a completely different scenario. But not only in EOPs, in any situation where justice system once gets involved, and your license is under review, and whether it is for these kind of EOPs or for standard processes of seizure, I don't think legally anyone can buy a new weapon. I mean, but yeah, can other things happen? Of course, but the legal acquiring of a weapon in Canadian context, I'm pretty sure is going to be, yeah, it's going to be very, very difficult. If someone ends up committing a fraud or buying weapon in someone other's name and then taking possession of it, all of those other freak and outside the box things can happen.
Awesome. And so I think you have sort of just touched on this, but I'll ask the question in case there's more you want to say. Someone was asking sort of, is this kind of application or order reported to the RCMP so it is connected to someone's firearms license? And it sounds like there is that connection from what you've just said, but
yeah, no, there is a direct connection, right? There is a there and I think something that we should understand is that there can be an immediate seizure of the seizing of the weapon under EOPs, but there are also just suspending of the license that can happen as well, right? So procedurally, there are lots of other things that can happen, and I like to believe, as much as I believe that guns are the most dangerous weapons around for violence, and I shared the data on how exponentially it increases the chances of lethality. I do believe that we have laws in place, but my only concern with someone's weapon usage is that it can happen different other ways.
thank you. And so a question here, and this person is sort of located in rural Alberta, and we had some folks sharing experiences that they've kind of tried to use these processes with some of the folks they work with, and that the courthouse or other actors aren't aware of this process or not up to date on how it works. And so just any suggestions around that, or also I think there was a question in the chat as well of just, have folks been finding that this works in their region? Because some folks are not running up against quite a few barriers in terms of awareness within the court system.
Yeah, unfortunately, that doesn't surprise me. The process has been announced in a very kind of vague manner. But I think potentially if organizations can advocate within their own courthouses, their government has released information about these laws, and the processes is listed on their website. So you could use that to kind of advocate with the courthouse, is my suggestion.
And again, although that's not the question, I just say that just speaks to the systemic gaps in our systems, where when the laws are made with the right intention, and we reviewed that intention together, what was the purpose, what was the intention, but the rollout of the application of that law is not backed with the enough resourcing of education and right kind of practice direction for our crown, and right kind of practice direction and training for our judges. So I feel like that gap comes from there. And maybe in the communities where you're finding that is happening, it is about collaborating with your local systems and finding ways to get that education and resourcing done. But it happens to a lot of criminal law changes. I can name at least 5 legislations that have happened in the last 10 years, and all with the intention of protection and safety, and they are not utilized routinely.
Okay. Um, there's a couple questions related to sort of the differences between licensed firearms and unlicensed. And so, what about scenarios where there are firearms, but they're not licensed firearms? Yeah, any differences there?
The EPOs don't differentiate between unlicensed and licensed. I think as long as the weapon is in that list that the code mentions, so firearms are just mentioned kind of broadly, you can apply for an EPO.
Great. And is there any type of sort of registry for those who have had their weapons removed or an ability to sort of see continuous offenders or kind of track that in any way?
Not that I'm aware of.
I don't think there is a registry, but definitely there can be a court order requested for a longer ban, a longer suspension, and a lifetime ban. So all of those are possibilities.
Okay. And I'm just reviewing what we've already covered here. I guess similar or sort of related to that in terms of what comes next after this. You know, someone has asked, do the victims get contacted to reassess risk level before the return of the weapons, kind of when the order might expire? And sort of similarly, like, is there a component of this that connects the person using harm to services? Because that feels like an opportunity here that this person has highlighted.
And I think that's what Deepa was saying, that like there's too many systemic gaps, and this would be a major gap, because the answer to both of that is no. Unless, so as mentioned, like after the 30 days, like in that 30-day period, a judge could decide that they want to create a longer prohibition order, and there would be a hearing for that. So maybe through that, there would be a little bit of that assessment where the survivor might be asked to provide evidence. But I don't think that within that 30 days, they're re-asking her about the risk.
And as the person who's asking this question is suggesting, I think that's where that collaboration of the system, these the not-for-profit and civil society with the justice system and the legal system comes into play, right? That ongoing support and continuum of service, and why we all should be right now reviewing our processes and looking at what can we do, how can we be better advocates and provide that ongoing support. Because from my perspective, risk assessment is obviously really, really important, but even more important is the safety planning. And I think we, as the service providers and from the not-for-profit world, we are so much well trained to do those safety plans. Like we have been doing it professionally for decades, and we understand people's ground realities and the resources that they need from an intersectional lens. So I do see that there is a gap. Uh, I also want to say that the fact that there is a risk assessment that also from the legal system, that doesn't also necessarily mean that it's a risk assessment based on the location of the survivor. So I think we should also all orient ourselves to understand that the risk assessment that the justice players and the legal system does, it is almost focused on, would this person be committing the crime again? And will this person, if given the weapon back, what will this person do? So the focus is so much on this person who is the perpetrator or potential perpetrator who they are trying to prevent the violence from, that those risk assessments do not center survivors' experience. And I think that's like a one piece of gap that I want all of us to be aware of and well understand, that those two risk assessments are not same thing. When I say risk assessment or you say risk assessment, we are thinking someone is sitting down and taking notes with the survivor, but that's not the risk assessment that they do. They do risk assessment of, will this offense happen again? Will this person be offending again? What are the chances of them buying misusing the weapon again? It's a different kind of risk assessment, and I want all of us to be grounding that reality in our work plans that we create around this.
Excellent, thank you. So Sort of building on the earlier question around like a registry or where this information might appear or be stored, does this kind of appear on someone's criminal record if weapons have been seized? Is there like a way to find that out or sort of see that for an individual? Yeah.
So the EPO orders don't create a criminal record. There's no charges associated to that. But if you breach the order, that would create the criminal charge and the criminal record.
Okay, thank you. Has there, to your knowledge, been any sort of pushback against the bill from the perspective that it's unjustly punitive to those who have not broken any laws? Or what, I guess, reaction to this in practice?
I mean, I have, I guess, heard some criticism of that, given that it is an ex parte order and stuff like that. But um, I, I mean, I think those are technical questions that um, play in a different field. Like, if we're looking at actual impact on survivors, I think that's a different question. Like, we should focus on if the law is effective. Um, because there's still, like, even if we take that criticism, like, there are still ways to appeal it and cancel it. So I don't think it's unnecessarily punitive in my personal opinion, but there has been criticism.
Uh, in fact, I mean, if you go back to when it was on the floor and being debated, there was intense opposition and faced intense objection and criticism. Um, and it comes from, variety of political and social spectrum. Um, Obviously, the owners of the guns and the people who have guns will criticize it for one reason, but we also had legal experts also criticizing it. Um, for my perspective, to be honest with you, when I see criminalization be the response to the gender-based violence without thinking through some of the implications and the complications, like as we are discussing right now, like we make laws with good intention, but with starking and glaring gaps. From me, that's where my criticism of any criminalization comes from, because I feel like that we make laws with glaring gaps all the time, and then some of the questions have been so good and thoughtful, right? Like, where is the tracking happening? Where is the support happening? Is the risk assessment happening with the woman on an ongoing basis, or survivor on the ongoing basis? And all of these, to be honest with you, are the reasons why someone like me would look at a law like this and be like, is this going to be really helpful? Is it going to be well resourced? Are we actually doing the prevention that we want to see? So yeah, so the criticism happens for various different reasons. But as Anchal said, and very eloquently, that I think right now the question that we have in front of us is has become a law, right? So now it has become a law. Every time this happens and something becomes a law, we are all about how do we utilize it in its shape and form, and try to make the system accountable for making sure that survivors are safer.
Excellent. Thank you. So keeping an eye on the time here, I think I'm going to leave the Q&A there for now. I will just, note for everyone, I know there are some questions we didn't get to. What we're going to do is we will share copies of the presentations and the recording afterwards. There are a few questions that came in that I think if you review the materials afterwards, you will see some of those answers in there. And then as well, I'm going to pass it to Margarita to share a little bit more, but we are also working on, or the Learning Network is working on a resource that we will be circulating to all of the participants as well. And so we'll share kind of the questions, and particularly the unanswered questions that we didn't get to, with those folks so that they can keep that in mind as they're drafting that resource. So it's not the end of the conversation, and I just wanted to make sure I was noting that. But given the time, I think I'll wrap up the Q&A there. So Deepa and Anchal, thank you so much for the presentations and for the Q&A and your thoughtful responses to everyone's questions. We really appreciate that. And I will pass it over to you, Margarita, And
Thank you so
Margarita,
much.
yes, go ahead. Sorry, I didn't introduce you, but go ahead and tell us a bit more
No
about the
worries.
resource.
No worries. Thanks, Leah. Yeah, I just want to take a moment to share something coming soon from the 6 organizations behind today's webinar. So we've been developing a written resource on red flag laws and survivor-centered practice, what these laws mean for gender-based violence and allied sector practice. So it's designed to be trauma and violence informed, grounded in real practice-based contexts. And so our goals are really to foster awareness and understanding on these laws, and more broadly, firearm removal, help service providers navigate the real practice questions that these laws raise, including, survivor safety and choice, systemic barriers, and the gaps in advocacy needs that remain. So it will be distributed by the Learning Network and all of the organizations involved, and we'll be sharing it on social media as well. The expected release is July 2026, so please stay tuned. Thank you, Leah.
Amazing. Thank you, Margarita. That's wonderful. And thank you, everyone who has allowed this to happen and participated today. So thank you to the organizations that were involved in putting this together. Action Ontarienne, OWAIT, the Ontario Network of Sexual Assault Domestic Violence Treatment Centers, the Ontario Coalition of Rape Crisis Centers, and Criva's Learning Network at Western. So thanks to all those folks. Thank you again to Anchal and Deepa for your wonderful presentations, to the interpreters for helping us out here and making sure everyone could participate, and to everyone who joined us and showed up. Thank you so much for your interest in this and your wonderful questions throughout. We really appreciate that engagement. So thank you so much, everyone, and stay tuned. We will be sharing the recording, the presentations, and the resource will be coming in July. So thank you so much, everyone. Have a great rest of your day, and you'll hear from us soon.
Thank you.
Bye.
Bye.